Hello, welcome back to the Dread Lawyer Neil podcast. I am Neil. This is episode 2 of my basic concepts videos. What we're covering today is going to be a particular code section in Virginia that many people don't understand or aren't aware of, and it is Virginia Code Section 19.2-81.3. This is the domestic assault mandatory arrest law. Now, I'm going to give you a thumbnail sketch as to why we have this law. In the past, professionals and academics determined that one of the best ways to cut down on domestic violence and continued domestic violence in situations where officers have already responded is to physically separate the people that are involved. They found that this was beneficial in that, one, it allowed the situation to calm down because people are separated, that they can't get at each other. And two, and perhaps most importantly, it allows people to sober up. Myself and any other legal professional that has been involved in criminal prosecution or criminal defense will tell you that the majority of violent crime, especially domestic assault and battery, is committed by people who are under the influence of alcohol. So it allows, this statute was designed to separate and allow people to sober up so that they don't come back or continue in this course of conduct. So let's look at the statute itself. What does Code Section 19.2-81.3 give the police? One, it gives them the ability to make a warrantless arrest for the crime of domestic assault or assault and battery. Ordinarily, for misdemeanors, the police cannot make a warrantless arrest. They must go and seek out a warrant or take someone down to the magistrate to get a warrant, and once that warrant is issued, then they can serve it. There are some misdemeanor offenses that are accepted in the statutes. This is one of them. I'll also note that we're talking about domestic assault and battery. Virginia Code Section 18.2-57.2 includes both assault and battery. An assault and battery is an intentional offensive touching of another person. An assault is a failed battery. In other words, you swing at someone and miss, that's an assault. Now, part 2, and I'll say this at this point, the statute does not list things 1, 2, and 3, and 4. It goes subsection A, subsection B, and so on. Subsection B of 81.3 states, as you can see on the screen, a directive requiring mandatory arrest if the officer determines there is probable cause that a domestic assault occurred. Now, bear in mind, when a police officer determines probable cause, that's all the amount of evidence that they need. Arrest can be made by probable cause. There doesn't have to be proof beyond a reasonable doubt, just probable cause. So how does the officer make that probable cause determination in the context of a domestic assault case? The statute lays out the following. What the officer is looking for is, based on the totality of the circumstances presented to the officer, was there a predominant physical aggressor? So those 3 words, predominant physical aggressor, that's what the officer is looking for. Now, the statute also lays out the groundwork for the officer to rely upon in making that factual determination. And the statute says, the standards for determining who is the predominant physical aggressor shall be based on the following considerations. 1, who was the first aggressor? 2, the protection of the health and safety of family and household members. 3, prior complaints of family abuse by the allegedly abusing person involving those family or household members. 4, the relative severity of the injuries inflicted on persons involved in the incident. 5, whether any injuries were inflicted in self-defense. 6, witness statements. and 7, other observations. That's a catch-all. So that's what the officer is looking for, and that's the groundwork that he or she is considering in whether there was a predominant physical aggressor. And it's not required, that finding is not required. A police officer does not have to find that there was a predominant physical aggressor in a domestic assault call. Now, we'll drop down to what I've called number 3. The statute also includes a directive requiring the officer to seek an emergency protective order if an arrest is made. An emergency protective order in Virginia is a protective order that lasts for 72 hours. If that arrest is made, then they must seek the EPO from the magistrate. Excuse me. If no arrest is made, but there is a danger of family abuse that the officer has recognized, then the officer shall likewise petition for an EPO. And then finally, there is a directive in the statute that the officer or law enforcement arrange transport to a hospital, shelter, or the magistrate's office for the allegedly abused person. And the police officer can arrange that in more than one way, or under some circumstances, the officer can transport this person themselves to the hospital, shelter, or magistrate. Now, that's a quick rundown of this particular statute. We often run into this issue in our domestic cases, and probably the majority of the domestic assault cases that I have defended. My client has been arrested under the mandatory arrest law. Many people don't understand this. Many people are not aware of Code Section 19281.3. They'll come to court, more often than not, it's the alleged victim, and say, hey, I didn't want this to happen. I didn't swear a warrant out. I didn't want the police to arrest him. I don't want to go forward. And of course, under this statute, that's the explanation. The officers don't have any discretion. Once they make this determination, they have to arrest. And more often than not, people understand it. They don't like it, but they do understand it. So as I said, that's a brief rundown. If you like my video, if you think it's informative and helpful, go down, smash the like button. If you like what I'm doing here, then I greatly appreciate a follow on my YouTube channel. Thank you. Have a good weekend.